Hi, I'm Peter Lee, a lawyer specialising in technology and unmanned systems at Vinters. I was recently asked this question on Twitter, and it requires an answer of more than 140 characters. So to answer the question, we need to establish who's at fault. If we assume there's no contract with the injured party, and that there was no criminal intention or criminal liability, then we need to establish whether a civil wrong has occurred. In common law jurisdictions, such as the United States, England or Australia, these are known as torts. And the particular tort we're concerned with is negligence. So the first thing to do is to unpack the facts of the case. And in doing so, we'll establish the potential defendants. These could be the operator of the unmanned system, the platform manufacturer, the autopilot designer, the software engineer, the inspector, even the regulator who gave authority to fly. And then for each of those defendants, we need to apply the legal test for negligence. I'm going to run through the English law test, which is similar in some other countries. And then for each element of the test, there's a whole body of case law to help with interpretation. So the first element to establish is whether a duty of care existed between the defendant and the injured party. First thing we look at is whether harm was reasonably foreseeable. We then need to examine the proximity between the defendant and the injured party. And then, is it fair, just and reasonable to impose a liability? Once we've established a duty, we need to see whether that duty has been breached. Did the act of the defendant fall below the threshold of a reasonable person? We then look at causation using the but-for test. So for example, we might ask, but for the negligent act of the software engineer when he was coding the autopilot system, the injured party would have suffered no harm. But this is quite wide, so we then apply a test for remoteness. How remote was the harm suffered from the defendant's negligent act? And then finally, we need to establish that damage has occurred, and that damage is a type that's recoverable under negligence. Here, death and personal injury probably is. Now the defendant might be afforded some defences at law. For example, consent of the injured party or some contributory negligence. And there are also a whole bunch of other practical and legal things a company or individual can do to protect itself in such a scenario. So I hope you can see it's really important to forensically unpack the facts of such a situation and then sensibly apply the law. So if you'd like to discuss this or any other aspect of the law and unmanned systems, please get hold of me at Vinters or look me up on LinkedIn or Twitter.